Your Honor, ladies and gentlemen observing these proceedings, we stand today at the intersection of authority and accountability in a matter styled Crockett vs. Committee Chair, Rules, Rulings, and Rebuttals, and though this may not be a criminal indictment or a civil damages claim in the traditional sense, it is, at its core, a trial about the rule of law within our own institutions and the limits on those who wield the gavel. My client, Representative Crockett, is not here merely as an individual aggrieved by the actions of a presiding officer. She is here as the living embodiment of every member whose rights, guaranteed by the rules that govern deliberation, debate, and due process, have been brushed aside in the name of expedience, partisanship, or sheer arbitrary power. When a committee chair believes the rules are decorative instead of binding, when rulings from the chair deviate from precedent, ignore the text, and silence proper objections, then the very concept of a fair hearing is placed on trial. And that is why we are here. We will show that this dispute is not about decorum as a matter of tone, but about decorum as a matter of law, not about momentary friction in the heat of debate, but about systematic misapplication of procedure to favor one side and muzzle another. The chair, entrusted with enforcing the rules evenly, chose instead to weaponize them selectively. Objections properly raised by Representative Crockett were ruled out of order without citation. Points of order that should have triggered clarification or correction were dismissed as argumentative or dilatory, not because they were unfounded, but because they were inconvenient. Motions permitted under the committee's governing rules were refused recognition, and appeals from the ruling of the chair, which are the ultimate safety valve in a deliberative body, were blocked, rushed, or denied in ways directly contrary to the written procedures everyone in that room had sworn to follow. These are not minor matters. Parliamentary rules are to a legislative committee what the Constitution is to a court. The framework that ensures that process, not personalities, governs outcomes. When the chair decided that her interpretations would float unmoored from the actual language in those rules, she did more than frustrate my client. She distorted the process itself. You will hear how Representative Crockett, well versed in procedure, raised timely points, cited specific rules, and requested that rulings be grounded in the written authority. Instead of engaging with that, the chair answered with broad, unsupported assertions. The chair has wide discretion. That's not how we do it here. The ruling stands. As if repetition could substitute for justification. Imagine a trial in which an attorney objects on grounds of hearsay, cites the rule, and the judge simply responds, "Overruled, because I say so," without more. We would all recognize that as a threat to the integrity of the proceedings. That is, in essence, what occurred here only in the context of legislative committee rather than a courtroom. We will demonstrate that the chair's rulings cannot be defended by the rules themselves, by the plain meaning of the text, or by prior precedent of the committee. They can only be explained as outcomes in search of a rationale, decisions shaped first by desired political result, and only afterward dressed up, thinly, as procedural necessity. My client's rebuttals, calm, grounded, and specific, were treated not as legitimate legal arguments about the rules, but as personal challenges to the chair's authority. In that inversion, where dissent is recast as disrespect, lies the true danger, because once the presiding officer believes that questioning a ruling is the same as undermining their stature, then every rule objection becomes an affront, every appeal becomes insubordination, and the entire safeguard system collapses. Our institutions were not designed to run on personal comfort. They were designed to run on rules. Representative Crockett did not come into that committee as a provocateur seeking chaos. She came as a member determined to ensure that the minority's voice, and indeed any voice that depends on process rather than raw numbers, would not be sidelined. On the record you will see her ask, calmly and clearly, under what rule is that ruling made? You will see her request that the text be read, that the time limits be applied equally, that motions recognized yesterday not be suddenly declared impossible today. Time and again, her efforts to tether the proceedings to the governing rules were met with impatience, interruption, or outright dismissal by the chair. That is why we speak today of rules, rulings, and rebuttals. Rules are the written commitments. Rulings are the chair's interpretation. Rebuttals are the essential right to challenge those interpretations when they stray from the written word. If any one of those three pillars is weakened, the entire structure tilts. When rules become guidelines, rulings become decrees, and rebuttals are branded as troublemaking, the outcome is not order. It is arbitrary authority. We will invite you to look not just at what was said, but at the sequence: a motion, a timely objection, an unsupported ruling, a respectful rebuttal, followed by a shutdown of debate. The pattern will be unmistakable. The chair did not merely err once or twice. She cultivated a practice that insulated her own decisions from scrutiny, treating any attempt to check her power as the problem, rather than as the very safeguard the rules contemplate. And so, as we begin, I ask you to hold in your mind this simple, guiding question: in a body governed by written rules, who truly holds the authority, the person with the gavel or the words on page? Our position is that the words on the page must prevail. Representative Crockett stands before you not seeking to humiliate a colleague or to relitigate every heated exchange, but to reassert that no chair, however experienced or passionate, stands above the rules that bind us all. In this proceeding, we will show you how those rules were bent, how rulings departed from them, and how her rebuttals, far from being disruptive, were the last necessary line of defense for a fair, lawful, and transparent process. Your Honor, when we turn from the broad principles of authority and accountability to the actual record of what transpired between Representative Crockett and the committee chair, we see not a single flashpoint of tension, but a consistent pattern in which the chair's rulings drifted further and further away from the rules themselves, and every attempt by my client to anchor us back to those rules was treated as an irritant rather than as a lawful safeguard. Consider first the simple, foundational matter of recognition. Under the governing rules of this committee, members are to be recognized in an order that respects established practice and protects minority voices, and objections or points of order raised in a timely manner are to be heard before the committee proceeds further. Yet in this committee room, when my client rose and clearly stated, "Point of order," the chair did not pause, did not acknowledge, did not inquire as to the basis for the point. Instead, she plowed forward, continuing to recognize only those members aligned with her preferred course, as if the words "point of order" had no special status at all, as if they were mere background noise. When Representative Crockett persisted, repeating her request to be heard on a point of order, the chair responded at last, but the response was not to hear the point. It was to declare, summarily, the member is out of order, without explanation, without citation, without even allowing the point to be articulated on the record. Your Honor, a point of order that cannot be spoken is not merely denied, it is erased. Imagine if in this courtroom an attorney were to stand and say, "Objection, Your Honor," and before the basis, relevance, hearsay, privilege could even be stated, the judge said, "Sit down, you are out of order," and the court reporter was instructed not to record the objection at all. Such a practice would not only be unfair, it would cripple any later review of the proceedings because the challenge would leave no trace, no moment where the law was invoked against the course of events. That is the first type of injury that occurred here, an assault on the right to be heard at the very moment when the rules demand that the presiding officer listen most carefully. It did not stop there. On multiple occasions, the chair announced new time limits for questioning that deviated from the written rules and from the committee's usual practice. When those newly minted limits were imposed on Representative Crockett and other members aligned with her, they were enforced with an iron hand managing seconds, cutting off mid-sentence, banging the gavel and declaring, "The gentlewoman's time has expired." But when members aligned with the chair's position exceeded their allotted time, the chair found a way to be lenient, to allow the member to finish, to make an exception just this once, and to ignore the stopwatch she had wielded so ruthlessly against my client. Representative Crockett, drawing on the rules that were written, not improvised, asked the chair to explain the source of this new constraint, to identify the rule that empowered her to change the terms of debate midstream, and to confirm that any such time allocation would be applied equally to all members regardless of party or position. In response, the chair did not quote a rule. She did not cite a precedent. She simply invoked a vague and boundless phrase, the inherent authority of the chair to maintain order, as if those words were a magic incantation that dissolved every other written guarantee. Your Honor, order maintained at the expense of fairness is not order at all. It is mere control. When order is truly lawful, it is constrained by rules articulated in reasons and transparent on the record. Here it was none of those things. My client's challenge to that asymmetry was neither theatrical nor personal. She did what any responsible member is supposed to do. She asked the chair to state the rule on which her ruling rested, and she did so in calm, measured tones. She sought clarity rather than conflict, asking that the rule be read aloud so that everyone in the room and everyone observing the proceedings could understand the standard being applied. The chair's reaction to this perfectly legitimate request was not to reach for the rulebook, but to reach for the gavel and declare that Representative Crockett was impugning the motives of chair and bordering on disorderly conduct. There is a profound inversion in that response. The member invoking the rules is cast as the troublemaker, and the presiding officer resisting any reference to those rules is cast as the guardian of decorum. That upside-down dynamic, repeated again and again in this committee, is at the heart of Crockett vs. Committee Chair, Rules, Rulings, and Rebuttals. And when my client attempted to exercise her right to appeal the ruling of the chair, a right that is not some exotic loophole but a basic mechanism of accountability, the chair moved swiftly to choke off that avenue as well. Rather than allow the appeal to be stated and a vote to be taken, as required, the chair declared that appeals shall not be entertained in this context, a phrase that appears nowhere in the governing rules. When pressed, she asserted that appeals would be dilatory or disruptive or an abuse of process, not because they were procedurally defective, but because they threatened to expose her rulings to the judgment of the full committee. Your Honor, in a system designed to be self-correcting, shutting down appeals is equivalent to cutting the wires to the fire alarm because one fears the sound more than the flames. Representative Crockett's attempts to rebut these rulings were treated, again and again, as though they were personal attacks rather than legal arguments. She pointed to the plain language of the rules. The chair answered with her feelings. She cited prior practice. The chair responded with her preferences. She referenced specific sections and clauses. The chair replied, "That's not how we're doing it today," as if the date on the calendar were sufficient to amend the rulebook. All of this unfolded on the record for the world to see, but in that room, in that moment, the only thing that seemed to matter to the chair was her own sense of control, not the integrity of process entrusted to her. It is this chasm between what the rules say and how the chair behaved that we ask you to examine with a careful, unblinking eye. My client is not asking you to elevate her preferences above those of the chair. She is asking you to restore the primacy of the rules above both of them. Your Honor, let us now address directly the anticipated defenses that the chair might offer, because in doing so we expose the deeper stakes of this dispute, and, more importantly, the essential role that rebuttals, firm, reasoned, grounded rebuttals like those offered by Representative Crockett play in keeping any deliberative body tethered to its own law. The chair will say, as she has hinted in public statements and in her responses on the record, that she was simply exercising the broad discretion afforded to presiding officers, that in the noise and heat of a contested hearing she had to act quickly to preserve order, to keep proceedings from devolving into chaos, and to prevent what she characterizes as theatrical tactics from hijacking the committee's work. At first blush, those words may have a persuasive ring. No one wants chaos, and no one disputes that the gavel carries with it a degree of discretion. But discretion is not dominion. Discretion is a space within the rules, not above them. It allows a presiding officer to choose among lawful options, not to invent options that the rules never contemplated. When discretion is invoked to justify actions that squarely contradict the text of the rules or long, settled practice, it ceases to be discretion and becomes usurpation. Representative Crockett's rebuttals, time after time, drew this line clearly. She was not saying, "You have no authority, Madam Chair." She was saying, "Your authority is bounded, and we must remain within those bounds." She conceded the chair's right to enforce time limits, to recognize members in an orderly fashion, to insist on relevance. What she would not concede, and what the rules do not permit her to concede, is the idea that the chair may rewrite those limits on the fly, selectively recognize or ignore members based on their positions, or dismiss points of order and appeals merely because they are politically inconvenient. The chair will also argue that my client's challenges were disrespectful or insubordinate, that by questioning rulings and citing rules in real time, she undermined decorum and set a dangerous example for other members. But, Your Honor, respect in a rules-based institution is not blind obedience. It is fidelity to the law that governs us all. If we accept the premise that to question a ruling is to disrespect the ruler, then we have stepped out of constitutional governance and into feudal deference. My client's tone was firm, yes. It was persistent, yes. But those are virtues when defending the minority's rights under a written code. The very structure of the rules anticipates and indeed invites such challenges. That is why points of order exist. That is why appeals from the chair's decisions are provided. That is why recorded votes are taken, so that members are not forced to swallow what they believe is error without protest. To condemn Representative Crockett for using those tools is to condemn her for doing precisely what the rules themselves contemplate. Another anticipated defense is that any errors made by the chair were harmless, that even if some rulings were arguably off the mark, they did not change the ultimate outcome of the committee's work, and therefore we should move on, treat these as minor procedural scuffles in an otherwise functioning body. Your Honor, that argument rests on a misunderstanding of what is on trial here. This is not a case about whether a specific motion passed or failed on a particular day. It is a case about whether the process by which motions are considered remains faithful to the promises institution has made to its members and to the public. In law, we recognize structural errors violations so fundamental that they undermine confidence in the fairness of the proceeding regardless of the result. Denying a party the right to counsel, for example, is a structural error. Even if the verdict would have been the same, we cannot accept that verdict as legitimate because the process was flawed at its core. Similarly, when a chair develops a custom of ignoring points of order, of blocking appeals, of selectively applying time limits, and of treating rule-based rebuttals as misconduct, the damage is not confined to any single vote or statement. The damage is to the legitimacy of the institution itself. Representative Crockett's rebuttals were attempts to prevent that structural damage, to insist that if the committee was to speak, it must do so through a process that the rules recognize as fair. Finally, the chair may claim that her interpretation of the rules is entitled to deference because she is experienced, because prior chairs have done it this way, or because no court has explicitly held otherwise. But experience, tradition, and the absence of judicial rebuke are not substitutes for the text of the rules. If experience alone could justify power, then no new member could ever challenge an old abuse. The very idea of reform would be extinguished at birth. If the phrase "we've always done it this way" were sufficient, then every unjust custom from our past would still stand. Representative Crockett's rebuttals were not attacks on the chair's experience. They were reminders that experience must be guided, and sometimes corrected, by the written law. And as for judicial silence, it proves nothing. Courts and tribunals intervene only when asked. They cannot disapprove practices they have never been presented with. That is why we are here now. This proceeding is, in a sense, the first formal opportunity to assess whether the chair's broad claims of discretion are faithful to the language and spirit of the committee's rules. My client's insistence that we answer that question is not a nuisance. It is a public service, in raising her voice, backing it with citations, and refusing to accept because I said so. As a sufficient explanation, she performed the exact function that members are elected to perform, to act as guardians of process, not as passive spectators to power. Your Honor, we now arrive at the natural end point of this inquiry, where we must ask not only what went wrong in this committee room, but what must be done to set it right, and, more broadly, what precedent we will set for every other forum, every other committee, every other arena where rules, rulings, and rebuttals collide. The remedy my client seeks is not vengeance, not humiliation, and not the permanent hobbling of the chair. It is, instead, a clear and unequivocal reaffirmation that the rules governing deliberative bodies are not ornamental suggestions but binding commitments, that presiding officers, however sincere, are not sovereigns but stewards, and that members who invoke the rules to challenge a ruling are to be protected in that role, not punished for it. In practical terms, that means recognizing that the chair's pattern of behavior, ignoring points of order, blocking appeals, selectively enforcing time limits, and treating rebuttals as offenses, was inconsistent with the rules she was sworn to uphold. It means directing prospectively that points of order be heard and ruled upon with explicit citation to the governing authority, so that any observer can trace the reasoning from text to decision. It means confirming that appeals from the chair's rulings are not acts of disloyalty, but integral components of the system, to be allowed when timely made and to be resolved by the full committee, not unilaterally silenced at the chair's discretion. It means insisting that time limits and other procedural constraints be applied equally, regardless of who holds the microphone, so that no member's questions are cut short simply because they are uncomfortable. And it means sending a message, unmistakable in its clarity, that when a member like Representative Crockett raises her voice not to disrupt but to defend the rules, she is owed not reprimand but respect. The broader stakes, Your Honor, reach far beyond this single dispute. In an era when public trust in institutions is fragile, when citizens look at their legislatures and too often see dysfunction, theatrics, and arbitrary power instead of principled deliberation, the way we handle internal conflicts like this one sends a powerful signal. If we shrug and say, "This is just how politics works," we reinforce the cynical belief that rules are merely tools to be twisted by those in charge. If we dismiss Representative Crockett's concerns as mere personality clashes, We tell every future member who witnesses an abusive process that they should stay silent, that challenging authority is more trouble than it is worth. But if, instead, we take this moment to affirm that even the most powerful gavel is constrained by the humblest printed rule, then we renew a different kind of faith, faith that law still governs, even behind closed committee doors, faith that minority voices can still invoke procedure to make themselves heard, faith that rebuttals are not nuisances but necessary correctives in any living, breathing democracy. My client stands before you not as a perfect person, not as a flawless advocate, but as a representative who, in the pressure and chaos of a contentious proceeding, clung to the one thing that should never be negotiable. The rules, she said, in effect, show me the authority. Read me the rule. Let us appeal if we disagree. Those are not the words of a saboteur. They are the words of someone determined to make the committee worthy of the power it holds. The chair, for her part, is not a villain. She is a human being who, like any of us, may have allowed the urgency of her agenda, the frustration of opposition, and the intoxication of the gavel to cloud her judgment about the limits of her authority. The purpose of this proceeding is not to brand her irredeemable, but to remind her, and every future chair, where those limits lie. Just as a judge is corrected on appeal without being cast out of the profession, so too can a committee chair be corrected without being condemned. What cannot be allowed, however, is the quiet normalization of a practice in which rules bend to will, rulings float free from text, and rebuttals are treated as disorder. That path leads, inevitably, to a place where the minority's only recourse is spectacle, where rational challenge is futile, and where the public's already thin trust erodes further with every televised hearing that looks more like a performance and less like a lawful proceeding. Your Honor, in Crockett v.S. Committee Chair, Rules, Rulings, and Rebuttals, the verdict you render will echo far beyond this particular quarrel. It will tell every member who watches whether the time they spend learning the rules is well spent or wasted, whether their right to object and appeal is real or illusory, whether the system will back them when they stand up for process, or leave them isolated and branded as troublemakers. On behalf of Representative Crockett, I ask you to choose the path that vindicates the law over personality, text over tradition, process over power. Declare that the rules mean what they say. Declare that rulings must be grounded in those rules. Declare that rebuttals, respectfully and lawfully made, are the beating heart of accountability, not a symptom of disorder. In doing so, you will not merely resolve a dispute between a member and a chair. You will reinforce the foundation upon which every fair hearing, every honest debate, and every legitimate decision in our public life must rest. For if rules, rulings, and rebuttals are kept in their proper balance, then even our fiercest disagreements can be channeled through a process we can all respect. But if that balance is lost, if the gavel is allowed to drown out the rulebook and silence those who dare to invoke it, then we will have surrendered something far more precious than any single vote or hearing. We will have surrendered the very idea that law, rather than raw power, governs us. Representative Crockett refuses to surrender that idea, and so do I. I respectfully submit that this tribunal should refuse as well.